Good afternoon, everyone, and welcome to this meeting of North and East Plans Panel. My name is Javed Akhtar, and I will be chairing today's meeting. Could I remind everyone that today's meeting is being live streamed on Leeds City Council YouTube channels so that the public can observe the meeting without needing to be present. North and East Plans Panel deals with applications from North, East, and the east of the city. The aim of the panel is to hear all the relevant information from applicants, members of the public, council officers to help members of the panel to make their decision. Could I now invite members and officers to introduce themselves and mute your microphone once you have introduced yourself. If I can start from the left, the video.
Lydia Lloyd-Henry, Principal Officer.
Hi, good afternoon. Gemma Garcia, Senior Highways Officer.
Good afternoon, Catherine Holloway, Sites and Policies Policy.
Good afternoon, Michael Miller, Member for Kippax and Methley Ward.
Good afternoon, Councillor David Jenkins from Killingbeck and Seacroft Ward.
Good afternoon, Councillor Amy Jones from the Horsworth Ward.
Good afternoon, everyone. Councillor Nicole Sharp from the Temple Newsham Ward.
Hi all, Councillor Jim McKenna from the Armley Ward.
Good afternoon, Sarah Holmes, and I'm part of the Plans Panel team.
Hello, Ryan Stevenson representing the Harewood Ward.
Good afternoon, Councillor Barry Anderson, Adeline Wharfdale Ward.
Good afternoon, everyone. I'm Debbie Oldham and I'm the clerk today.
Good afternoon, Philip Plumtree Valley, Principal Legal Officer and Legal Advisor to the panel this afternoon.
Good afternoon, Jonathan Carr, Head of Development Management.
Hello, David Newbury, Lead Planning Officer for the Plans Panel.
Thank you, everyone. Moving to the agenda, can I ask the clerk if you can go through item 1 to 5, please?
Thank you, Chair. Under agenda item 1, there are no appeals against the refusal of inspection of documents. Agenda item 2, there are no exempt items, And under agenda item 3, there are no late items. Under agenda item 4, could I ask members to declare any interests?
Yes, Chair, although it's not pecuniary, when I arrived at Civic Hall today, I realised that one of those speaking in objection is known as family friend. So I haven't discussed any of the application beforehand, so I approach with an open mind, but it's for the record, Chair.
Thank you for that.
Thank you. I'll continue now, Chair. Under agenda item 5, we have received apologies from Councillor Hesselwood. That's it. Thank you very much, Chair.
Thank you. Item 6, minutes of previous meeting held on 29th of June 2023. Do members accept these minutes are true and correct record? I'll assume correct unless indicated otherwise. Are members happy to move these? Thank you, Councillor McKenna. Anyone to second? Thank you, Councillor Sharps. Are there any matter arising? No. Item 7, can I ask the officer to present the report, please?
Thank you, Chair. So this application relates to a retrospective proposal for the siting of 1 static caravan and 1 touring caravan with some associated works, including the movement of an existing gate. So the application has been brought to Plans Panel at the request of ward members. Ward members objected to the scheme that they consider the use of the land, which is part of a wider allotment site and is protected green space through the Kippax Neighbourhood Plan under Policy GE1 through the Site Allocation Plan under Policy GS1 isn't suitable for the proposed use and doesn't meet the appropriate test for very special circumstances. Local ward members feel there is an impact on residential amenity and that there is a clear demand for allotments in the area which isn't being met with the current supply, and this is evidenced through waiting lists. So the next slide. So this slide shows the site outlined in red. As you can see, there's a hedge buffer to the east and south and west, and there are residential properties to the south of the site on Sandgate Terrace, which is down in this area here. The site is protected by local green space policy under GE1, as mentioned earlier from the Kippax Neighbourhood Plan, and this development would be contrary to the policy, and the appropriate tests require the applicant to put forward very special circumstances. And you can see to the northeast corner where the static caravan and touring caravan are sited, and also to the west corner where historic buildings are sited. So the next slide, this shows a separate site to the west. There we go. So that's the separate site, which is outlined in green, and that's to the west of the current site. So although this site is not related to the application, there has been a recent appeal decision for a similar form of development. It's important to note the differences in personal circumstance here. The inspector and the LPA did not consider the very special circumstance of the family should be given significant weight, and this was due to the family living on a pitch on another site which had planning permission and the applicant's children not having links to a local school. The very special circumstance in this case were only afforded some weight as the family had a stable living situation, and the inspector stated that an unsuccessful planning application would not have resulted in a disproportionate interference with their human rights. For the application brought to members today, the very special circumstances put forward by the applicant are considered to have substantial weight in the report. The family were living roadside previously to moving to the site at Sandgate Stables, and 2 of the applicant's children are attending the local primary school. The impact on the living situation of the children has been given substantial weight within the report in line with planning policy for traveller sites and the National Planning Policy Framework, which links to that planning policy. The proposal will be contrary to policies GE1 of the Kippax Neighbourhood Plan and GS1 of the SAP and G6 of the core strategy. However, it's for members to decide today whether the very special circumstances set out are considered to outweigh this. A temporary planning permission, which is personal to the applicant and his family only, has been considered to be suitable in this instance, as this will allow for more sites to come forward with the local plan 2040 call for sites and will not disrupt the children's education or safety. A temporary permission will also allow the allotment to retain its designated use, and a condition is also proposed for the land to be returned to its original state following the cessation of the permitted use. So it's important to note as well, there are 2 sites which are currently provided by the council, Cottingley Springs and Kidacre Park. They total 49 pitches, and all of those pitches are full, and the council doesn't yet have a 5-year supply of deliverable sites. Leeds Gate, the charity which has been assisting the applicant's family, is aware of other families which have been in a similar position, and they're on a wait list for the council's provided pitches for about 2 years so far. So the next slide, which is slide 5. This slide shows the current retrospective proposal, which shows some alterations to the site layout, such as the movement of the gate and also the addition of bin stores and cycle stores. So in the northeast corner of the plot, they're the static caravan and the touring caravan. And to the west corner of the plot, there's space for vehicles to park, and also the historic stable-like agricultural buildings. To the south are 2 open grassed areas. And then in the centre, you've got a gravel path which leads down to the rear of the site. So the next slides, these are the floor plans and elevations and photographs of the static caravan. And the next slide is the touring caravan. So I've also included some photos of the site, which show the static caravan and touring caravans in situ, and the open grassed areas and the entrance to the site to the south. So they're the caravans in situ. And then the next slide that shows, it's quite difficult, so it was quite a bright day there, just to see the open grassed areas. So there's been some additional questions which members raised while we were on site today, and we've got some of the answers to those. So the electric ports, which were located, if you can see on the photo here. Oh, sorry, just back one slide again. Yeah, there. So they were over in this corner here on the fence. So those electric ports run the electricity to the static caravan, and Northern Grid have connected those ports in. And then regarding the access and the access path, which is the gravel path here. And then if you go to the slide just before, sorry, and you can see there the hard standing. So we've been made aware that those were input in autumn in 2020. So the restoration condition which is proposed will include the removal of the gravel and hard standing once the temporary permission has lapsed. And we're also proposing another condition which will require the applicant to submit a site plan which basically shows the land uses of each section of the site. So if we can go just back to the slide with the site layout, sorry, just earlier. Yep, just one before that. So it would require the applicant to just say the use of each land, and then that would be restricted to, say, the allotment land here or open space, use for horses here, and then the use for the static caravans. Thank you, Chair.
Thank you for that. We have speakers against the proposal. Could I invite them to the table? Once you are ready, you have 4 minutes to share between you to put your case to the panel. It's Mr. Whitfield, Mr. Courts, and Councillor Lewis. Sorry, Smith. When you're ready.
Afternoon. Firstly, as a resident on Sandgate Terrace, it has been devastating to see the changes on Cartersfield allotments over recent years. And this site in itself has had many changes. Unfortunately, the photos weren't shown of what the allotment looked like prior to illegal development. Although recommendation is temporary, there is a need to reflect on the detrimental harm this illegal development is having on the land. Substantial weight must be given to the land's designation, even though it states this does not alter, it is already not presenting as green space, and it is at risk of being irreparable. Furthermore, this allotment does not sit in isolation, away from other allotments and the surrounding areas. Yes, other allotments have outbuildings, but these are not causing destruction to the natural habitat, and nor are they a dwelling. Where the caravan is sited is not where buildings were prior to the previous owner, and the hard standing and building was erected, and then the building was taken down and a static caravan placed on there, and that was open to enforcement action. There is potential that approval of this application's recommendation can put other allotments on Cartersfield at risk of similar developments. I have considerable concerns as to how the outline monitoring of the allotment will be carried out, especially in respect of who resides on there, without putting further responsibility on local residents to report this. The emotional harm that this and similar illegal development is having on the community must be given consideration. The planning officer's report does not give weight or reflect to this. And the planning inspectorate only last year detailed the impact that the loss of this green space would have on the mental and physical well-being of the community. Well, I must emphasise that we are already at this point and it is already having a detrimental impact on the mental well-being of the residents.
Yes, good afternoon, everybody. My name is Jerry Whitfield. I'm the current chairman of the Committee of Volunteers, which manages the Castleford and District Allotment Federation. First of all, I would like to contradict the solicitor's letter that's on this application, which claims that the Allotment Federation gave a right of way across a strip of land adjacent to Sandgate Terrace onto this allotment. The Allotment Federation does not own that strip of land. The Land Registry refused only a couple of years ago to recognise our ownership of that strip of land, and therefore I don't see how the Allotment Federation can grant a right of way across a strip of land that we don't own. Furthermore, that letter says that the requirement to update or to keep updated the roadway indicates that the right of way exists. Well, I've got in front of me the land registry document for that plot, and it does not include that strip of land. What it does include is a half of the track which runs through the centre of the field, and that is the correct entryway onto this strip of land. And when it says there is a requirement for the owner to maintain the roadway, that's the piece of roadway that it's requiring them to maintain, and not the strip of land outside the allotment plot. So that's the solicitor's letter. Carter's Field allotments, and it's not Sandgate Stables, it's Carter's Field allotments, have been allotments since 1958. And in fact, Mr. Shackleton's parents who worked that allotment used to actually sell their surplus produce to the local women. My wife used to go onto that allotment and buy the produce.
Can I ask you to finish your sentence, please, sir?
That's it, sir.
Thank you. I take it the 4 minutes are over. Councillor Lewis, is there anything that you feel that has been missed? I'll start the first question to the objectors.
Thank you, Chair. Our objections as ward members are set out in the paper, so I believe the committee has, the panel has had a good sight of our objections. A couple of points I would underline, Chair, and happy to answer any questions from the committee. First of all, the Kippocks Neighbourhood Plan was voted for by the residents of Kippocks, of which I am one, in February 2019. It is a recent and relevant document setting out the status of the land, the compelling planning arguments why this land is not suitable for the use proposed as a gypsum traveller pitch, again, have been established in so many committee meetings and inspectors' reports as here. I do not believe the amenity of how the site will be managed in terms of utilities is covered adequately in here. And finally, one of the buildings that was referred to as historic is actually, if I can refer members to the planning paper, it is a building in paragraph 13 covered by that enforcement action. So I don't think it can be considered a historic building. Chair, I'll leave my comments there, but more than happy to answer questions. Thank you.
Thank you. Any questions? Councillor, go on.
Thank you, Chair, and I welcome your U-turn on being able to ask, is there anything amiss? We'll make sure that we make use of that later.
Yeah, if I can, I mean, I started off with the first question, and I think this tradition came from yourself, Councillor Stevenson, if I remember correctly. Councillor Lamb, yeah.
We'll look forward to continuing it. Just, Councillor Lewis, one of the main arguments put forward here is around personal circumstance and access to schools, and I just wondered, as a ward member, if you could just inform us how many primary schools are in the locality, so perhaps in Kippocks alone.
Thank you. There's 3 primary schools in Kippocks, one in Alton Bywater, one in Great Preston, one in Ledston, one in Micklefield, and schools in outside our ward in Garforth and Castleford as well.
Any other questions? Yes.
This is one that's directed at Jerry mainly. Paragraph 52, page 27 of the report references the green space background paper, which suggests that there's a surplus of allotments against the standards of a policy for open space. Is it your understanding that there's a surplus of allotments in the local area?
Well, Mr. Chairman, we have 100 tenants across 4 sites in Kippocks, and we have a waiting list as well for allotments. So there may be a surplus across the area, but there certainly isn't a surplus in Kippocks. One of the members on the waiting list has been on the list since September 3 years ago. So 2021. So there may be a surplus elsewhere, but there certainly isn't a surplus in Kippax.
Dr. Anderson?
Just briefly, I don't. You may think, Councillor Lewis may think I should know the answer already, but when the site allocations plan was being discussed the last time, did this site come forward at any time by any of the landowners as a potential development site, or has it never ever been considered as a development site?
Thank you, Councillor Anderson. My recollection is that it has never been brought forward as a development site, either by the Allotment Federation, who were a substantial landowner on the site, or any of the previous landowners. Indeed, when some of the plots have been sold, they've been marketed as allotment land to underline that status.
Anyone else? Councillor McKenna?
Sorry, thank you, Chair. There was concern regarding what was referred to as Carter's Field allotment regarding the approach road. When we were on site today, we saw on one side it was a paddock, and on the other side there was just grassland, scrub grassland with some dumping on it. But we also noticed there was at least one electric charging point on it, and we didn't quite understand that. I will ask the applicant the same question, but could that be the fact that you think that this development may turn out to be bigger than actually what we have before us?
So I think in terms of the area itself, so I've been part of the Castleford District Allotment Federation as well. So in reference to the strip of land that you referred to, that's something that the Federation are still consulting with Land Registry about, because on previous documents, it's believed that it should be registered to the Castleford District Federation. As Jerry mentioned, access has always been via the middle track of Carter's Field. So Carter's Field is what it has always been known as. So there's Carter's Field, and then to the other side of that, there is another load of allotments that are referred to as Sykes's Field. The electric point that you're referring to was put in place by the previous owner, and there was some discrepancy around what was happening there. But nothing further came of it in terms of information shared with residents, and enforcement were involved anyway upon restoring the land back to its original purpose.
Thank you. I think Councillor Lewis is wanted to come in.
Yeah, thank you, Councillor McKenna. Just on the question of land ownership, I think it's important to look at you'd been on the, unfortunately I couldn't come on the site visit this morning, I had the West Yorkshire Combined Authority meeting, but the roadway is adopted highway, but the land beneath the adopted highway is not owned by the City Council. The City Council's ownership only starts at the curtilage of the properties. So I think that's an important thing to say on the land ownership question. There's land bordering a highway that's definitely not either adopted or owned by Leeds City Council.
So thank you. Anyone else? Right. Thank you very much for your time. And we also understand we have an agent in support of this application. So if you can come to the table, please. You have 4 minutes to address to the panel, and when you're ready.
Good afternoon, panel. It's Mark Scatchard from Mass Design Consultants, who are acting on behalf of the client. Mr. Smith, the applicant, has been residing at the site since June 2022 with his 4 children of school age. James Andrew Smith, 5-year-old, Adam Lawrence Smith, 9, Diane Smith, 12, and Leona Smith, 14. Both the younger 2 children attend Kippax Ash Tree Primary School. The development proposes retrospective permission for the siting of a static touring caravan, and there's no other domestic paraphernalia on the site. Just a point I want to just raise from the previous comments. The land was purchased by Adam Smith, and it had enforcement action for a steel frame building. The building was removed by Mr. Smith The hard standing that the building sat on was retained, which now sites the caravans. Mr. Smith and his wife have placed significant importance in allowing the children to gain education through the state school process, and this is one of the reasons they have decided to occupy the site and purchase the land. The council are unable to demonstrate a 5-year supply for traveller sites, and on speaking to Leeds Gate, they've sort of confirmed that there's a shortfall of sites available in the Leeds area. Prior to moving on the site, the family had to live roadside before siting themselves at the application site because of lack of alternatives. If permission is refused, then the likelihood is Mr. Smith and his family have nowhere else to go, so they would be moving to another unauthorised site or living roadside. Living roadside now is an illegal act. This would seriously harm the best interests of the children through impeding their educational prospects and having access to medical care through an allocated health centre. Couple of points just wanted to raise. The land has right of access and has been confirmed by the solicitor John Howe and Co in Pudsey. Another point that was raised was the electric point that's on the site was actually fitted by my client, and it's just an additional electric point to the site. There are, from what we can see, 2 to 3 redundant allotments on Sandgate Terrace. So we're sort of struggling to understand why there's the shortfall of allotments. And the last point we just really want to raise, there's electric as have been outlined on the site. The tenant, Mr. Smith is paying council tax. He has waste collection weekly, which includes toilets being emptied, etc. They're all registered with local doctors, and 2 younger children are registered with the primary school, with 2 older children being educated by Leeds Gate.
Thank you. If you switch your microphone off, sir. Any questions? Yes, sir.
Thanks, Chair. Paragraph 15 on page 19 states that the family had to leave the Cottingley site. Is that referring to the council's Cottingley traveller site?
Yes, that's correct. They were living on the Cottingley Spring site and basically left the site because they didn't feel it was an appropriate place for the children. The council are aware of a lot of issues on that site. So they basically moved off the site and went roadside for probably 6 to 12 months. And then they bought the piece of land that came up for sale, which is where they are now.
Thanks. What were the issues that they were having on the site?
There's a lot of, from what I can establish, there's been a lot of violence between families on the site. They had no issues on the site, but they basically, with the children being of a young nature, Adam and his wife decided that it wasn't the most appropriate place to bring the children up. So they left the site for just general safety reasons, really, and wanted basically to reside somewhere where they could sort of, I suppose, live a normal family life.
Given their problems on the site, if a suitable plot on the Cottingley site or the Kidacre site were to come up, would the family be comfortable moving on to one of those plots?
I think with a lot of sites there are issues, and there are limited sites available. So there's 2 main sites in Leeds. There are other private sites, but they are private sites similar to the situation what we're discussing today. So you do generally find that the larger the sites, the more families there are, the more problems. But they would be happy, as I say, going on a site where there's less issues as such. But the Cottingley is well known with the local authorities having its own sort of problems.
Councillor Stevenson and then Councillor McKenna.
Thank you, Chair. So when you say that your client was living roadside, was that at the period when the 2 children were admitted into one of the local schools?
So the children, when they were living roadside in various parts of the Leeds district, they would attend a local primary school, but they wouldn't be there for such a long period. So they've been in various schools. They wanted stability for the children. So when they had the opportunity to buy the land, that's meant that the kids can, follow a sort of a full education sort of process. So that's the reason why they've resided, and as I say, the laws are now that if you pull up roadside, then it's against the law. So it's a catch-22 situation, really.
So just to check the chronology of it, then it's the case that the children were admitted to the local school because they'd occupied the land, rather than them occupying the land because the children were in the school.
No, they occupied the land, and then they registered the children with the local school. The two older children are educated through Leeds Gate on their education process. Right. The secondary school children.
So they're only in that school by virtue of the fact they're occupying that land at present.
That's correct.
Okay. Were you advising your client at the point that a number of planning breaches occurred on the site?
So my client was, when they purchased land, they were aware that there was an enforcement case for a steel frame structure that was on the hard standing that sites the caravans. They were totally aware of that, and on completion of the said land, they removed the structure at the instruction of myself because there was an enforcement case against that. So that was removed. The hard standing was retained and then submitted as part of the application today.
And finally, can you confirm that your client currently owns the land?
My client currently owns the land, yeah. It's
freehold.
Yeah, freehold.
Thank you. Councillor McKenna.
Thank you, Chair. You did say that they were formerly living on Cottingley Springs, which is a gypsy and traveller site that has existed for many, many years, not far from my own ward, I have to say, and I have visited on a number of occasions. But the fact that they actually give up the pitch there and went roadside could be deemed that they intentionally made themselves homeless.
Yeah. The reason they left there is because there's been a lot of issues I know local authority are aware of. A lot of family issues, not with their family, but they just felt they want a safe environment. They had the opportunity then to purchase the land after they'd been roadside. So they've been living roadside for probably 6-9 months before they moved on to Sandgate Terrace.
But as you know, and most of us in this room will know that we buy the property or we rent a property, but we can't always pick our neighbours. Even in my street, I won't mention where they live, but I can tell you that I have problems with at least one neighbour. And in modern living, the way we can't afford to own vast tracts of land with no other housing around there, we will always get this, and there has to be compromises on this. And could you tell me what compromises was made by your client to actually settle the dispute or the unease they had with living on a registered site that obviously meets all the requirements and then moving off and going roadside? That is a bit that I'm struggling to understand.
I think from speaking to the client, when they were living on Cottingley, it was the issues that were around them, and they didn't want to bring their children up in that environment. So it was their decision to move from the Cottingley site and go roadside, and living roadside, they were living independently. So there were no other families living with them. They were just living with the 6 of them, 4 children and the 2 adults. And then subsequently, they then were looking for a piece of land to purchase, which is what they've done. And they've purchased it freehold in Kipax with a view of getting some stability. Now, there's just a lack of sites, and there's 2 main sites for the whole of the Leeds district. If you speak to Leeds Gate, they have sort of indicated there's about 1,600 families in the UK waiting for sites for travellers. But the government have brought in legislation that doesn't allow travellers to pull up roadside. So it's just a difficult situation that the families find themselves in.
I'm still struggling to quite understand. As I said, the fact that they moved off a recognised site with all the facilities necessary, is puzzling to me. I lived there 9 months. Why would anybody want to do that? But secondly, I can tell you that in Cottingley Springs, which is not far from where I represent, there are lots of kids, young children who go to local schools, and indeed they are settling in very well. One of them is certainly Army Primary School, which is in my ward, and they're well looked after, they're well educated. It doesn't seem a very sound reason for going roadside. Surely if there was complaints with neighbours, we have a neighbourhood nuisance which could intervene and take the appropriate steps. But as I say, it's a very drastic step to make yourself homeless and decide to live, probably was all last winter on the roadside. Yeah. It's a big step. Can you tell me, if any, what steps did your client take to try to resolve the issue of their problems with living on Cottingley Spring sites?
So they left, as I say, I'm only going off what my clients explained to me. So they left the Cottingley Spring site, spent that 6-9 months roadside. Within that time, they were they're heavily involved with Leeds Gate. So when I first met the family, the Leeds Gate were totally aware of the family and their circumstances. And they were aware that they'd purchased the land and they'd left the Cottingley Springs and they'd been roadside for 9 months. So that's all I was told. But I was told the same thing from my client as I was from Leeds Gate, who have commented on the application.
Just one more question, Chair. I'm afraid they're arising from the answers of the representative. Did they receive any advice from Leeds Gate? And did Leeds Gate give them any guidings on how the matter of Cottingley Springs could be resolved? Because I know Leeds Gate very well. We all do around the table, and I have dealt with them many times over the last 30 years. But it seems to me that they had a role there to actually resolve the issue. Were they called upon, and did they in fact act on your client's behalf?
As I say, I was in touch with Leeds Gate once I had a call from my client, but once he'd purchased the land. So when I went to actually see him, he was on the land, living in the caravan and the touring caravan. And then that's when he explained that he'd been in touch with Leeds Gate. I got in touch with them. I deal with them regularly. And they explained that, yeah, the family had been roadside, previous to that at Cottingley Springs, and they resided and they were assisting them with getting the kids into the local primary school, doctors, dentist, and just, yeah, aiding the family at the time. And that's, as I say, that's literally everything I've been told.
Thank you. I've got a couple of other colleagues who have shown the interest to speak, but can I just trying to clarify my own mind, Mrs. Scutcheon. At the beginning of your remarks, you said between 6 to 12 months, the family was on roadside, and then it is turned down to 6 and 9 months. Could you exactly, please? Yeah, could you? Yeah,
9 months.
6 to 9 months. Okay. Councillor Stevenson.
Thanks, Chair. There's a couple more questions arising from answers. The answer you gave me earlier about schooling. So you said there were 2 children in the local primary school, but then 2 older children who weren't in mainstream education. Is that right?
No, the 2 older children, the general sort of route of travellers' families is the children go to primary school, and then not all families go into secondary education through a general secondary school. So what they do is they get educated through Leeds Gate and are taught through Leeds Gate. So Leeds Gate are the ones who are providing the education for the 2 older children. So they don't go through the mainstream secondary education.
Well, the law is that every child must be in education. So you're saying the provider of that is Gate?
Is Gate, yeah.
2 older children?
Yes, that's correct.
So why can't the 2 younger children be educated through Gate as well?
It's a standard sort of traveller family thing where they want to get the kids to get the basics in life and get a primary school education. So it's quite common when you speak to most families that the kids go into primary education and then they go to secondary education through Leeds Gate. And that's quite a few of the families that we've dealt with over the last few years.
So is your suggestion that Gate, as a registered education provider with Ofsted, aren't providing what you describe as a basic standard of education for secondary school age?
No, I haven't said that. I've said that basically it's the choice, the family. They don't send their kids to a state secondary, and it's done through Leeds Gate.
It was the last bit was the key I was looking for. It's a choice.
Yeah.
So it's a choice made by the family
for secondary education
and primary.
No, not the primary.
Well, it is because they've chosen to move to the area to put their children in that.
They're putting the kids through the primary school. Most families do.
Okay.
That we deal with.
Just move on to the land in question. You mentioned it was purchased freehold. What was the purchase price? Can you tell us?
16,000. I've got the in the file. I've got the freehold deeds, and that's been confirmed through the solicitor.
How much do these? We saw the caravans on the thing. I mean, if you go to any sort of holiday park on the East Coast these days, I think they go for about 80 grand. These caravans these days. So, what's the asset value of the two caravans on site?
The asset value of the two caravans on site is about 40,000.
Okay. I did a quick right move check before I got here. There's 61 properties in Kippax for sale between 70,000 all the way up to £500,000. Is there a reason why, if the family wanted to be in the area, they couldn't have acquired one of those properties?
They are from a travelling gypsy community. So you tend to find with the gypsy traveller community that they don't live in houses like the rest of us. And it's a cultural thing. So they tend to live, as I say, roadside, which is legal, or on a private site, or a static site that the local authority provide.
Thank you, Councillor Sharp.
Thanks, Chair. Just following on from what Councillor McKenna said, it is true that you can't, wherever you buy, whether you buy or wherever you live, you can't choose your neighbours. But in relation to this application, if it was granted and after 3 years the family had to move away, where would, if they've moved from Cottingley Springs and put the family basically on the roadside with children, where would they go from there if there was no availability on that side?
I think the general problem has been involved with quite a few of the travellers' families is that just a lack of sites available. So if there's more sites available, then rather than trying to contain all your travellers onto 2 sites within the Leeds area, which is just totally impossible, I think there's more sites, then they'd happy go to a site that was appropriate. But there are other individual sites with temporary consents in Leeds that have been granted, and some that are also permanent that have been confirmed by Leeds Gate.
At the point of purchasing the site, was the family aware that they required a planning permission?
When they purchased the site, they were aware they need to apply for planning consent. And they understood that they needed to apply for retrospective because they'd already by then moved on to the site. So I explained to them that the reasons and what was required and what process we needed to follow, which is in theory what we've done and ended up at the stage today. I've explained to them that if planning was granted, it would be a temporary consent until a site became available or other sites within the Leeds area. And I said it would never be, as I say, it's a temporary measure with a view that at some stage in the future, the land would have to be reinstated to its original use.
Councillor McKenna, thank you.
Thank you, Chair. Apologies for coming back. I did get involved a little bit with the line of question. I wasn't getting very far, and there certainly wasn't answered to my satisfaction. But when I asked the question of the objectors, I did talk about the already fixed electric point that we saw on site. And I mean, people can, if they go to the map without putting it up, it's as you come in the gate on the right-hand side, across from the paddock area. It's quite a large section, and there are 2 fixed points that have servicing and probably electricity there. I can understand the objectors being concerned that there is possibly breaches of the planning permission in the pipeline already. And I think it'd give considerable comfort to members around the table and perhaps local residents if you could say that that grassed area, which was allotment, the points could be removed, and in fact they could be restored to allotments. There's no other purpose for it. If you were able to make that guarantee and put it in the planning permission, I think we'd all feel more at ease with what is being proposed today.
Yeah, the electric was basically, originally they were running off a generator, which can tend to be quite noisy. So Adam basically got the supply put to the site and the electric provided. So that's the electric's been provided to the site. Generator's now gone. The two pieces of land to the front, he just tends to keep his 3 horses that he's got on those land. There's no intentions of ever to put any caravans, any structures on there. So they could be retained for allotment use or green space, etc. We'd have no issues with that.
You're saying could or will be, yep. And you would be willing for that amendment to the planning application?
Yeah, we'd be happy to, as I say, the intentions is, as the site is now, and it's servicing just him and his wife and his 4 children, we're happy for the 2 areas to remain as green space, and we're happy to sign an agreement or a condition, agree to a condition.
Take Councillor Miller and then Councillor Jones.
Sorry, we're going back to the same thing, but it's slightly different. So it's a temporary permission, 3 years, and the plan is that other sites during that time would come forward. So the emphasis is on your client to now be considering looking for other sites. Is your client currently in the process of looking for alternative sites?
Yes, my client has always looked at alternative sites, but it's like you speak to Leeds Gate and they are quite helpful for the travelling community, and they're just constantly say, yeah, you can register for the sites, but there's just no sites available. So I've got a client who's 25 down the line in Barnsley for a site, and they release about 2 sites a year. So it's the time issue. It's just there's a lack of sites available. But yes, to the answer, yeah.
Yeah, I completely understand that. And as the report says, on average, about 2 sites come up each year. And obviously this permission would give your client 3 years to live on this site. So on the basis of that, in the next 3 years, 6 sites would come available. So it's pretty likely that an alternative site will not become available in the space of this permission. In particular, given the fact that your client, yeah, it's clear the report, and I completely understand there's a lack of plots available for the travelling community. But your client obviously did have one of them on the Cottingley site and chose to leave it. Now, obviously, I don't know what happened on that site, and I can completely understand that it might not have been an appropriate circumstance for those children. But given your client's opinions in that regard, it's very likely that there will not be an appropriate site that will come up in the 3 years. And so given that, I find it hard to believe that after 3 years, we won't effectively be granting an indefinite plan for the family to stay there.
Regarding other sites that we've dealt with in Leeds, that has not been the case, where they've basically reapplied and got an approval. They've got maybe another 3-year temporary, but it's never been a fixed approval. Each authority seems to have a different take. Wakefield, they just issue a 5-year temporary and make sure that they register on every site that's available within the area. But where they've come off one site and ended up on their own land as one family, somebody who's on that list has gone then back onto that site. So and you tend to find that they tend to have children quite young. So you're just constantly creating that issue of more sites being needed, and there's just a shortage. It's just nationally as well. It's not just Leeds, it's everywhere.
Councillor Jones.
In terms of when they left the Cottingley site, what measures did they try to take to resolve the issue before they actually left the site, before going roadside? Because I find that rather strange that you would just suddenly decide to move off. So can you have an explanation as to what measures was taken?
What they explained to me was that they were on Cottingley. They'd got, 4 younger children that, as I say, have gone through the ages already. They were living on that site. So it wasn't directly at them as a family, but they basically felt that for their kids' safety, that they didn't want to be on that site. So they made the decision to move away from that site and go roadside and put themselves in the situation where, by pulling up on council land, it's against the law. They might pull up on private land and be stay there a little bit longer. But again, the issue was that they've just moved around from land to land over that 9-month period. So they've done it for good intentions for the children, but maybe sort of long term now, they didn't think they'd be in this situation today. But again, I've explained the need for planning consent, temporary consents, etc.
I don't think that actually answered my question, to be honest. My question was, I would assume, and I'm guessing, there will be a process for them to go speak to somebody and say, I'm uncomfortable with this. And what measures did they do to actually try to maintain their ability to stop on that site? Or was it just a simple matter that they were moving off?
They made the decision to move off. That's what they've told me. I literally do not know any more than that. I don't know the circumstances of it, but it's not something that I've seen it before. It's quite a common thing that, properties tend to be on top of each other. The kids are on top of each other. And as I say, there's just a lack of sites. If we provide more sites, then we wouldn't be here today.
Can I just bring David before I bring Councillor Anderson?
Yes, thank you, Chair. I'm very much aware, and it's very obvious, this is an incredibly difficult application for us to deal with. And as a result of that, I can fully understand the questions members have in respect to the context and the sequence of events and why we're in the position that we are now. And that is, it's helpful to have that background. But when we move forward, ultimately, the decision that members are going to have to reach is on the proposal that we currently have before us and the circumstances that we have before us. I have been in a very similar situation to this at appeal and raised similar issues to the issues that members are raising in respect to the history. And an inspector came down on me very hard to say that that's not relevant. I don't know why you're asking that. I'm not saying it's not relevant for you to ask that. I said it to understand the context, it's helpful. But you have to deal with what's before you and the merits of the planning application as it stands, rather than the history. And it is clear, and we do know, that this is an abuse of planning control, that this is a breach of planning control. It started without the necessary planning permissions. So it's very clear that that's the position. And it's also very clear, and the officer's report is clear on this, that this is a proposal which is contrary to many of our local planning policies, particularly those which deal with green space. And it all boils down to whether there are, as the report describes, very special circumstances that exist. And that's what members have got to have regard to. Thank you, Chair.
Thank you. Councillor Anderson.
Based on the advice we just received of the free.
We've just received, I won't go down the line that I was going to go down to try and get clarity in my mind. So I will withdraw what I was going to do.
Thank you. Anyone else? Thank you very much, sir, for your time. Can we now move on to the officers, if there are any questions to the officer? Councillor Stevenson and then Councillor Anderson.
I think I have 4 questions, Chair. The first is just what happens after the 3 years. So we've heard that a suggestion that another 3 years might be granted and then another 3 years after that. What happens if the gentleman moves off and wants to sell the land? He's heard he's paid £16,000 for it, which seems probably quite a lot for an allotment. So how would we ensure after 3 years that enforcement action is taken? And what powers would the council have to forcibly remove somebody or who, to grant planning application, as argued a case of protected characteristics?
So with the 3-year permission, enforcement would be able to take enforcement action if anyone resided on the site for longer than the 3-year permission, unless obviously, like Mark said earlier, they put in for another temporary permission. And in terms of the restoration of the site, so the permission would be 3 years specific to that family only. So it wouldn't be a planning permission for anyone to reside on that site. It would be specific to the applicant and his family. So after the applicant had left, whether it's within the 3 years or less, it wouldn't then roll on to anyone else. And in terms of the actual site, so we're planning on having a restoration condition, which would include the removal of the gravel and hard standing. So that would remove all of that material and it would be back to allotments.
So 2 sub questions arise out of that. Once the site's been vacated and the occupants left, how are you going to ensure that the site's put back to where it was before? If there's no fixed abode and they've hooked up the trailer and left, how do you enforce that?
So it's just through the enforcement notice that we'd ensure that the applicant removed all the materials that are on the site.
So I have a live planning enforcement case in my ward where the council is not able to serve the notice because they don't know the address of the person who owns the land. So again, how are you going to enforce the action if you don't know where the person has gone to?
Yes, it's a fair point, Councillor. Yeah, the enforcement notice would be served on any owners of the land. So that's how we would intend to catch them, as it were. And yes, we have hit difficulties in the past, and it's the way that it's a glitch in the system. It's very difficult to deal with it. But if it's if it is difficult to track down an owner, that can obviously delay and frustrate the process. But it doesn't mean that we don't try.
And so once we sort of set a precedent in the case today, if we grant planning application on the terms given, what would stop the owner saying to the potential buyer coming in, I'm going to sell the land, but I'll tell you what, if you put your kids in a local school, then you can then apply for planning application. They'll have to grant it because that's how they gave it to me. So do we risk, if we give that permission today, that if an identical application comes in with a different owner, the same site, that we would be duty bound to grant further planning application in future?
Yeah, we just have to judge what comes for us on the planning policies we have in place at that particular time. If there's no change in the planning policy context and the circumstances of a different family are the same, then we may end up in a very similar position.
Thank you. Right, that was question 1, A, B, and C. Question 2. Normally on planning applications in more rural areas, when we're dealing with planning applications for things like stables, there is a ratio of land that's needed per horse. My wife has 2 horses, and so I happen to know what that ratio is. So are we saying that if this application comes forward today, and the speaker earlier made reference to 3 horses, that we're accepting that there's going to be 3 horses on as part of this land? It's grazing land, And therefore, is that land big enough to accommodate 3 horses?
I think he did say 3 horses today, but I did get 2 horses back by email. So I'm not sure if he's made a mistake there, but we probably need to double check whether it's 2 or it's 3. And on the ratio, I'm not sure if David's able to answer that one.
I was trying to think, but you already know the answer, Councillor Stevenson. You've indicated, is it 0.1 of a hectare per horse?
Well
Is
done,
that it?
yes.
All right.
So is the land big enough?
In terms of that ratio, I suspect it falls under, because the site, as far as we're aware, the site is in totality is 0.15 hectares, so it may fall below that. In a planning sense, we don't actually have a policy which sets that out that I can think of. But I accept the point. There is an issue about the welfare of the horses and looking after their horses in an appropriate way.
And from a planning point, presumably we could, via condition, require or remove any existing permitted development rights, for example, that might come in future for any sort of stables, or stables wouldn't be permitted development, but structures, field shelters for horses, for example, that later on there could be a classic Q argument.
Yes, we could do that, yeah.
Question 3, Chair. How was the land banded for council tax? My understanding is it normally goes back to the 92 valuation based on property prices. So how do we apply council tax banding to a caravan and a tourer?
I think that would be a question for council tax. I don't think we can answer that today, just on how they're calculating that.
I accept it's not a planning argument, but the reason I ask is just because some of the supporting documents was given in a sense of the refuge collections, etc., are being paid for. So I think we'd probably want to understand in future as well whether that banding is accurate and how that applies in terms of the drain on the council services. My final question is, there is a lot in this pack around the Equality Act. And in fact, really, the planning merit you're asking us today to make a judgment on is basically all around personal circumstance and the protected characteristics. On plans panels in the past, when we've had quite emotional cases put before us of a family that might need to expand a dwelling because they have, I can remember one which was a disabled child, and they needed some more space in the property for the disabled child, which of course is a protected characteristic. The planning arguments were always, well, we judge each case on its individual merits, but we have to look at the application based on planning merits and not based on the circumstances of the individual, because when they move, the person coming in might have a different circumstance. So are we being asked to apply significant weight to a protected characteristic for one protected characteristic in a way that we wouldn't for any other across the council, be that disability, gender, sex, sexual orientation, etc.?
So the protected characteristic is one part of the weight in the balance, but the main substantial weight which we're applying within the report is the very special circumstances surrounding the children in this case. So the safety of the children and the education of the children, that's where the very special circumstances substantial weight is lying really. Protected characteristics and Equality Act, that is part of the weight, but it's not the full extent of the weight, which is why the previous application on the site adjacent was refused and wasn't given permission.
So I'll save my comments for comments on the other point. So if on on a percentage then of the weighting, what are you asking us to apply to the school issue versus the protected characteristics? And I ask because if this is appealed, if we were to refuse an appeal, at appeal, what weighting would be put there? Because it may well be, for example, if the schooling situation is answered and we're just left with a protected characteristic, how much weight does that alone carry, specifically when we've already won one appeal based on that?
Yeah, before I answer that bit, just going back to the previous point about other cases, I can think of other cases that we've dealt with, and one that came to this plans panel, where we've made an exception to planning policy in the best interests of the child. And the one I'm thinking about is there was a case out in the Greenbelt where we granted a larger extension beyond the 30% than we would normally grant, so that they could provide appropriate accommodation for the children of that family who had particular needs. And I can also recall cases where we've granted planning permission for extensions to houses, accepting what you set out is quite proper and quite right, and that's our starting position. But we've been presented with arguments in respect to the particular needs. Maybe more often than not, it's the child has a particular disability, and to allow that child to stay in that particular home and have that stability and staying within that local school system, we have granted planning permission for longer periods of for extensions that we wouldn't have otherwise granted. So I think it is a case of each case on its own merits. With regard to a lot of this, as Lydia's saying, from an officer perspective, we applied an awful lot of weight on the best interests of the child. If you took a circumstance out where they didn't have young children at the local school, then we'd be in a very similar position to the appeal that we fought further down Sandgate Terrace. The other thing that distinguished that appeal was that, and we'd have to have regard to this, is that that family on that appeal also had a permanent base, an alternative place to go to. So that was a distinction. But certainly, if you took away the children from this case, that would significantly reduce the argument for the grant of planning permission. I don't think we could put a percentage on it, but it would significantly weaken the case.
Councillor, before I bring Councillor Anderson in, you shown interest to ask a question earlier on. Are you? Okay. Yeah. Before I bring Councillor Anderson, one thing that was raised, 3 years temporary. If it gets granted, we will not roll it on to anybody else but the gentleman who has applied for it. But let's say after 3 years, if he applies for a planning permission again, it gets granted, what does he? We don't have any control of him renting it to someone else, if you can understand, or is there a condition on that as well?
Yeah. Yes, the planning permission would be personal to Mr. Smith and his family. So if they rolled it on to another family, then it would be in breach of that planning permission.
Councillor Anderson.
A couple of things. One is we often get updates at our training on the current thoughts. What are the current thoughts of the inspectorate on this type of case now? What's the case law? Are there a lot of cases being approved now? Because if I was an inspector, I'd say to myself, fine, okay. I told Leeds City Council whenever we set the site allocations plan up, you had a shortfall of spaces. What have you, Leeds City Council, done in the interim to try and meet that unmet need? You have come forward with amendments to your site allocations plan in the meantime and have not brought forward any further sites. So what's the likelihood? What I'm getting at is, in 3 years, is there any likelihood that we will have identified any sites in the city for this, other than the ones that just suddenly appear from nowhere? Because it would appear to me that if it's greenfield or green space, it stands little or no chance of being included in any forward plans, so that you're then down to brownfield sites. There are issues with some of the brownfield sites that come on that may be ex-industrial, because they're then not close enough to facilities for any family to be able to. So what I'm getting at is, what is the current position? Is an inspector, or have any inspectors recently approved schemes using the exception that that officers are suggesting we give due weight to today? Is there any evidence that that has changed? And the other thing is, back in 2005, when we took power, there was a list of sites that the council were actively considering as potential locations. That was then revisited about 5-6 years later. Where are we? And are there any plans for alternative sites that might come forward in the future in this location that are on that list that had been prepared in advance?
I'll leave the second part of that for Catherine to answer. Now, I'll have a go at answering it, and Lydia might want to add to it. I'm not aware of, certainly within our patch, within Leeds, of well, within the Eastern Half, of recent applications for travellers' pitches. There was a case which was reported in the press recently, in the planning press recently, where a council got very heavily criticised for refusing an application and questioning the actual status of the applicant, whether they were a gypsy or a traveller. And it was felt, the inspector felt, that that was wholly an inappropriate line for the local planning authority to take. But ultimately, what a planning inspector will do is what we have done in terms of presenting the report. They'll just judge it against the planning policies that exist at the present time. I don't think they'll necessarily go back through that exercise of saying, well, they may say, well, Leeds doesn't have a 5-year supply, but I don't think they'll go back and say, and they've been told they needed it in the past and they still failed. I think they'll just deal with it on the current policy context and have regard to the fact that.
So on that point, about lack of a 5-year land supply for housing, where we were losing appeal after appeal after appeal, doesn't apply in these.
No, sorry, I'm not saying that. No, there is a requirement to have a supply of traveller sites, and we fall well short of that. And Catherine will be able to explain that in better than I can.
Well, I'll try. Thank you. Yeah, so we do have a requirement of 5 years, and that's set out under Core Strategy Policy H7 and the Site Allocation Plan. The Site Allocation Plan goes so far in identifying new pitches. We've got expansion at Cottingley, and we've got Kidacre Street in the city centre. Kidacre Street is impacted by proposals for HS2, whether that comes forward or not, we don't know. So there's uncertainty there. We currently have a land supply position, or a year supply position of 2.7 compared against our requirement to deliver 5 years. So that is substantially short. We are progressing through the requirement of policy HGR2 in the site allocations plan, a review of gypsy and traveller sites. And that process has started through the local plan update 2040. So we've started initial scoping, which we consulted on earlier this year. As part of that work, we are doing a call for sites, and we will be entering into a specific needs assessment for gypsy and traveller and travelling show people to further investigate land availability, land supply, land deliverability. So yeah, I can't comment on the I'm seeing the next question is the waiting lists, but we're not delivering and haven't been able to deliver the number of pitches that have been identified and allocated through the site allocations plan. So we are woefully short. I don't know if that answers your question.
What about list that was in existence of potential sites that when we were in power, we didn't want to take forward, but is that list still in existence? Does anyone, I mean, there's nobody from housing here, and it was housing that actually produced the list, to be quite frank. It was a housing department list of sites that they felt would meet need in various parts of the city. It was controversial, let's be quite frank, it was controversial. I just wondered if that was still, because if there isn't the likelihood, where are this family going to go? You know, if we're not going to have something, where are they going to go? They've got to go somewhere. You know, a bit of a dilemma. That's the point I'm trying to make. It's very difficult for us to say no to this, but then say to them, but you've got no hope of actually finding somewhere else. We're in a bit of a bind.
Councillor Anderson, perhaps this could be for other forum, and I absolutely understand. Yeah, I absolutely understand, but this is not the right forum for it. Councillor Miller?
Yeah, we've spoken a lot about the very special personal circumstances, but in paragraph 50 on page 26, there's a suggestion of another difference between the previous adjacent proposal, which was rejected, and this one. And it states that there are some differences in respect of the characteristics of the respective sites that will have some material bearing on the environmental effects associated with the development. I was just wondering if you could expand a little bit on what those differences are.
So I think the differences that were cited were that the original plot, which was referenced in the appeal, was more central within the allotments, and this one is further into the corner of the site, which is just a few rows down. So I think that was the main characteristics in terms of the material impact.
Sorry, I don't quite understand. So is it in terms of the actual position of the whole allotment itself being on the outskirts, or is it in terms of where the caravans on the allotment area are?
Yeah, in terms of the location of the allotment site, so it being further along on the road. I think it's on the corner of Sandgate Terrace and Sandgate Grove, maybe, I think.
What environmental effects are made worse by the fact that the other allotment was more central than this one?
Sorry, I was just checking a planning history of another traveller site that we had. So sorry, the question was in respect of the environmental effects of the...
Yeah, so the report states that there are differences in respect to the characteristics of the respective sites that will have some material bearing on the environmental effects associated with the development. But I don't understand how obviously, you know, the sites themselves are very close together. We saw it on the site visit earlier today that you can see it from the site. I don't understand how the fact one is on the corner and one is located 200 yards slightly down the road is a material difference.
Yeah, it's the environmental effects in the planning sense, in the way that they're meant in that report, relates to matters, as you probably appreciate, matters of visual impact, amenity, traffic movements, etc. So it's the physical effects associated with the use. The point the report is trying to make is that because, as Lydia was pointing out, as this site is contained set further back from the road, further away from the residential properties as compared to the site which is in the centre of Sandgate Terrace, then the occupation of that land is marginally less apparent than it would be on the other site, and that's the extent of it, really.
Yeah, fair enough. I'm not particularly convinced by that, but that's fine. I understand it. So just another quick question. So we've said that the application itself is specific to this family. So if another family were to move onto the site during these 3 years, whose responsibility would it be to monitor and report that?
So that would be for the enforcement team to ensure that the family that are living on the plot are the family which the permission is specific to, and any change in that, I'm assuming council tax would also be an indicator of that. If that had changed, if names had changed on council tax, we do have some ties with council tax on HMOs and on this as well.
So how often would the enforcement officers be visiting the site to ensure that the family are the current family?
That could be something which is discussed with enforcement, and we can agree a time scale which they regularly check that the site is being occupied by the correct family.
Okay, thanks. Would it be reasonable to assume that that burden would likely fall on neighbours and other residents of Sandgate Terrace to report that to enforcement officers?
I think it's fair to say in enforcement generally, we do rely on local people to draw to our attention any breaches of planning control. But we, as Lydia says, we also do go out, and this site has been monitored on a regular basis by colleagues in enforcement, as has the other site on Sandgate Terrace. So it's a combination of the two. Come back on that appeal. Lydia just drew my attention to an appeal decision also, that I think this probably dates from 2018, but it is an application that did come before this plans panel at that time. Same ward, actually. It's a site in Hollinghurst. And that was, again, a retrospective application for a traveller's pitch, which was set up on a piece of open land diagonally opposite a terrace of properties. We refused planning permission on a number of grounds: visual impact, over-intensive use of the site, and highway safety reasons. Went to appeal. It was allowed on appeal. The inspector, looking at the appeal summary, attached significant weight to the unmet need and provision for alternative sites, and that seems, from the summary I'm reading, to be the compelling point that led the inspector to allow the appeal.
Can't see any. Okay, Councillor Stevenson.
Very quick follow-up to Councillor Miller's point. How do you define family in terms of checking whether they're family or not? Is it prescribed that it's the applicant, spouse and descendants, rather than Auntie Fanny moving in and all the rest of it?
Yeah, it'll be specific to the names of the applicant and then their 4 children.
Right, can we now move on to the comments, please? Any comments? I've got Councillor Sharp and then Councillor McKenna.
Thanks, Chair. I just think with applications like this, if we've to consider them under very special circumstances, I think there needs to be a bit more input from the applicant. You know, to just say that they've made themselves homeless and then we've got to consider it on that basis, I don't think is good enough, really.
Councillor McKenna?
Yeah, a very similar point to Councillor Sharp. I did try to bottom some of these questions with the applicant's representative, and all I was really getting was a circular argument, which came back, you guys ain't got enough pictures, what else can we do? And the children's schooling is important, which we all accept. Nevertheless, there are issues regarding the voluntary moving from Cottingley Springs. We have no knowledge whatsoever of that, and my attempt to actually find anything about it really was quite frustrating, really. As I say, I was just getting circular answers, but no really substance to the questions I was asking. I did get one interesting point when I said, would the applicant be prepared to restore the grassland to the side of the paddock to allotments? And he seemed to indicate they would. But of course, we haven't got this on the report. And I might suggest to me that, and I know a lot of people will comment, that deferral may well be an appropriate way forward in this to get the answers. I've certainly not been able to achieve around the table, and I think a lot of members feel the same way.
Thank you. Councillor Stevenson.
Thank you, Chair. One word springs to mind today, and that's choice. The planning officers had a choice to make a recommendation. The ward members, Councillor Lewis, Councillor Harland, had a choice to take that choice away from officers and bring it to plans panel in order so their residents could be properly represented. We have a choice today to make on the planning merits put before us, and crucially the applicant had a number of choices. We've heard that it was a choice to leave a fixed site and make that choice for the family. It was a choice to move onto the site in Kippax before planning consent was given, and therefore instigating enforcement action. It was a choice to send the children to the school in question. There was a choice, an active choice we heard made, not to put the older children in mainstream education and access different provision. That is a choice that could also be made for the younger children. So when I think about any subsequent appeal and waiting and the law around equality, which is the law, so we must abide by it, even if we want to disagree with it. Although there's a right to a family life and a right to human rights, which is a given, and we do agree with that part, there's got to be an element of choice. Nobody's saying that this is the only choice available to fulfill that requirement in law. There's got to be some personal responsibility on the applicant, surely. They've made a number of choices that have led to this position, choices that if they hadn't have made would have had a fixed home for the family and those children in education. And it's that issue of choice to me that I think balances out the question that we've been asked. And when I had the answer from Mr. Newbury around effectively the weighting of the two parts, is that, as I understood the explanation, the significant weight goes to the personal circumstances. Because if they were removed, I think were the words you used, David, if we remove those and it was just on the protected characteristic argument, it's pretty much similar to the appeal that was 2 plots down that we successfully won. So when I just come back to that issue of personal circumstances, and that's where we're putting the weight, and effectively it's because we want to keep the children, or the applicant wants to keep children in school and access to services, that's not the only choice to fulfill that. There are other options the applicant can take to deliver that within law. So on that basis, I'm not convinced today by the arguments put forward, nor indeed really by a need to defer. I think to me it's quite straightforward that we've made a decision previously on the plot next door. I'm not convinced that this is wholly different to that one, and unless anybody else wishes to make a comment, I'd put forward the motion that this be refused, Chair.
Before I take your motion, Councillor Stevenson, I'll bring Councillor Jenkins. Is that a comment, Councillor Jenkins? Or...
Yes, I think it's a difficult issue, and in a way I would prefer to defer this matter, because I think there's lots of issues that haven't been taken into account. And if there's an issue about this case from 2018 about unmet need, I think that's quite a significant factor. I'd also like to really hear from Ellie and the people at the gate, the school, and the effect upon the children as to if they were moved from that school, particularly the primary school children, but also that I think we have to, the choice has been taken away by this government, not allowing sufficient support to travelling families. I think they've been stigmatised, affected badly by this government, not allowing legally roadside places. And so I think there is a limited choice for traveling families as to what's available to them. And I think they live a very insecure life. And, we've been trying to look for negotiated stopping places. Even there for 28 days, it's quite a struggle. So I'd also like to see if we could find a reason to involve Carrie and Gareth from the Travellings team to also get their view on the situation. So I'd prefer to defer this and involve more people in the discussion. Yeah.
Before I take your motion as well, David, is there anybody else? We've got two motions on table now.
I'm just going to second Councillor Stevenson's motion, that's all.
Okay.
So, Chair, so I understand if legal want to advise that we would have to vote first on my motion to refuse, and if that falls, then we'd vote on to the deferral.
Bring David in, and then obviously we'll take your motion and take the vote on it.
Yes, thank you, Chair. I just need to clarify with Councillor Stevenson what the proposed grounds for refusal actually are, so that we're just clear on that.
Choices.
You can watch it back on YouTube. My choice. There was choice. A significant weight shouldn't be given to the personal circumstances, because it's not the only circumstance available. There are others, and it's the applicant has chosen to be in the situation. So, for example, there are school places that could be made available was he to move somewhere else. So it's a disagreement, a respectful disagreement, David, with the officer report around the weight given to personal circumstances, and a view that, as we've already won one case on the protected characteristic argument on the plot next door, then why should we differ from that now? We've taken two separate points.
So could I put what you've just said in these terms, that it's contrary to policy in respect of local green space and green space, and that the circumstances of the applicant aren't sufficient to outweigh the harm which occurs? Is
there's a reason,
and then there's a contextual reason which supports that case, as it were.
The reason you're a senior officer, yes, put that very succinctly.
Right. You were the proposer and Councillor Anderson was the seconder. All in favour? Anyone against? Any abstentions? No. So that's lost. And then we had Councillor Sharp, was it? Councillor Jenkins, sorry. Do you want to repeat your motion again, and then we'll take someone as a seconder?
Yeah, I would prefer to defer this matter for further investigation and consideration of a number of matters regarding the unmet need, the issue of choice, the officers from different departments of the council, the travellers team, the gate, and the school.
And if you can include the elected members?
And the elected members.
Anyone to second that? Councillor McKenna.
Thanks, Chair. And certainly I would like more information of why the family left or were forced away from Cottery Springs, which seemed to create the problem. In council terms, it would have been deemed as making yourself intentionally homeless. So there must be some good and compelling reasons, which I was unable to find out from the applicants, although I asked the question several times. I think Councillor Ryan Stevenson made a very good point regarding horses and how much land should be available. I know the policy did seem a bit vague on that, but also animal welfare is something that we're all very important and concerned about. And the third one is that there seemed to be an indication that the field could be returned to allotment, the unused part. and seemed to say that they would be prepared to enter into such an agreement. Again, we can only do that if it's part of the planning application. And for those additional reasons, I think I'm happy to defer at this stage.
And you've just seconded it, basically. Yeah. Okay. Thank you. I mean, it's good that you mentioned about the horses, and all of us are into animal lovers. So it was good that Councillor Stevenson brought that point. So can we add that onto it as well? And also the allotments that you talked about earlier on about the grass space at the front. So all these things, and if David can sum it up again, and then we'll take the vote. And I'm sure he'll do well.
Thank you, Chair. Yeah, so just working from the bottom of my list, as it were. So picking up Councillor McKenna's points, more information in respect of the return of the land to the allotments, what land's affected, how we would actually control that. More advice in respect of number of horses and the land that should be available for them to graze. Moving on to Councillor Jenkins' points about the advice from the travellers teams, the gates, the school, and the ward members in respect to their input into it. More information in respect of if planning permissions refused, the consequences for the children, particularly of primary school age. More information in respect of unmet need. And then I think we'll probably have to put this within the context of some legal advice about the scope of consideration for members and the context and how much weight can be applied to the history, as it were, and why the applicant left Cottingley Springs and how material that is to the consideration of this particular planning application.
We're all okay with that, yeah? So let's take the vote. All for? Against? Abstain? So that's carried. Right. That concludes the agenda item 8. We've just done time, and the next meeting will take place Thursday, 24th of August at 1:30 p.m. That concludes the business of today's meeting. Thank you for your attendance and contributions. I now declare the meeting to be closed. Thank you.